can only borrow the money song for 15 seconds or we have to pay them money. Something like that.
Okay.
I don't know what it is.
Okay, I got you.
It's all of our show producer people. I don't know. They know that stuff. I'm just here doing whatever. So
I got you.
Well,
what are you going to talk to me about today? I'm looking
Oh.
forward to seeing what you got for me.
Oh my gosh. This is like Stump the Expert. I have people talking to me probably, I don't know, at least 4 times a week, close to every day, where they are inheriting money and they don't know what to do with it. And I know that's always, to you, that's that's dreamy language, Gary. So I have people that will ask, and let's say, well, what do I do with my money? And I always have to tell them, I am not a financial advisor. I'm not licensed to do anything like that. I am your attorney. And I said, well, where did you put your money? I go, well, that again, I can't talk about because I am not a licensed professional. So I tell them to listen to the show. So one of the things that came up, and I just thought this was kind of fun, is that it's another situation. We talked about them a little bit before. The market moves around a little bit. So I always go, let's try this scenario. So this guy, he is 67 years old. He inherited about $700,000, which is like fantastic. And he's, it's more than he's ever had because he has saved up about 300,000. So he's figuring in 67, I saved up 300,000. That's not enough. He's going to get his Social Security was around, it's quite high. It's around $3,500 a month, which surprised me. He didn't save up any more than that for retirement, but he got his Social Security, which is like $3,500 a month. And he's starting to collect that. And then he's got about $300,000 in investments. He doesn't need a lot of money, but he inherited 700. So now he's going, wow, maybe I can retire. And I told him, I would ask you, what would you do in that situation? 700,000, 67 years old, probably wants to retire in the next 3 or 4 or 5 years. Is that going to work out for him?
Yeah, I do think that's going to work out for him. And I think what we would probably do, it sounds like one of them might be qualified funds and the other one might be non-qualified funds. Is that right? Or are they both qualified funds? What do you think?
Yeah, well, the 350, he actually, you're right. I forgot that the 350, he has that in a 401k from the company he used to work for.
Okay.
That he works for. So he is still working for the same company and he has a 401k at that company and it's $300,000. And that's basically all he had put away. There's some cash, but not really much to speak of. And then 700 he inherited, that was actual just money. That's not qualified funds at all. So it's a little more fun to play with.
Okay. Yeah. All right. So in that scenario, I would probably, I wouldn't really swing for the fences in that case. There's a time when you want to swing for the fences and people are trying to catch up and you're trying to get some pretty high returns. And in this scenario, this is where we play a little bit of self-defense, if you would. So it's kind of like, Gary, of course, right now we're right in the middle of football season and, people, the football teams are playing for the playoff. And then sometimes you'll have like a football team that's already made the playoff and their last game, they really want to save their quarterback. So they'll just set their starting quarterback because even if they don't win the game, they're still going to make the playoffs. So they do that in a defense so that they don't destroy their team or destroy themselves. So that's kind of what I would do here is I would go into a little bit of protect mode, conservative mode. He's going to have, a little more than $1 million. That's not something you want to play around with and even do a 10% loss, because if you lost 10%, now you're down $100,000. As you know, and I know, you've got to return back 100%, just to get back to even. So I wouldn't do that. I would probably go pretty conservative. I would probably even look at something that protected that principle so that he would never lose, not even a single cent, and let it grow 4 years, 5 years. And then when he's ready, we would turn on a guaranteed lifetime income and I would stagger it. And another term that I would use would be laddering, and think of a ladder as you go up the ladder. So I would stagger it or ladder it so that every 5 years he gets a cost of living raise in his payment. So he would be on a guaranteed lifetime income, which would be like like a pension. So he would draw a monthly pension, and every 5 years he would get a raise. And there would be no risk to the principal. That's probably what I would do.
Okay. That makes sense. And that's interesting, because so many times you think, if he has $1 million, is that really enough to retire? And I have people that will say, gosh, $1 million, I think I need 2, and I'm gonna have to work for the rest of my life. I'm gonna be at my desk, I'm gonna fall over dead. And I go, no, I don't think so. I mean, it's tight, but I like what you're saying. And I think part of it then, Anthony, what's happening is, if the guy is still working, he still has income, and he's able to draw Social Security, do you then, you kind of calculate it out where because he has some income now, and he's asking you, when do you think I could stop working? We just have to be ready that when his income, whichever, I can't remember what it was, $6,000 a month, when his $6,000 a month goes away, that's where we have to kind of step up the 6,000 coming out of his investments, and then maybe ladder it from there.
That's right. And then we would ladder, and then every 5 years he would get a pay raise.
Okay.
And that we do that as a cost of living, so that we can keep up with the cost of living for retirees.
Oh, okay.
That way they're not stuck. See, the people that get hurt with inflation are people that's on a fixed income and they're retired. And so all they draw is that X amount. Well, if all you draw is 6,000 a month and inflation's growing at 9.5 or 10, then it's eating away at your purchasing power as to what you can purchase. So we do this to prevent that. We do this to ladder up so that they get a pay raise.
Okay, excellent. All right, thank you, Anthony. So we are going to come next. I'm going to ask Anthony a question that's bigger numbers, based on a different scenario. His number is 931 retired. He knows everything you need to know about retirement and getting ready for retirement, however long you are out. 931 retired is his number. You can also easily go to Anthony Wright's website, and that is BibleSafeInvesting.com. And he talks about how to invest your money. Basically, invest your money where your mouth is, so that it is in companies that actually support your, conservative values and family beliefs and things, and which is really wonderful. That's why he's on the show with me, because I like him and I like what he does and I love his theories. 931 retired. So I've got another scenario for Anthony, and I know putting him on the spot it's tough, but he's always willing to do it with me. So we're going to do it again coming up next here on the Word on Wealth. If you want to get a hold of me about your estate plan, it's 855-500-TRUST. So listen up when we have next a retirement scenario for Anthony, and we'll test his mettle coming up on the Word on Wealth.
You don't need to know everything. You just need to know where to find answers you can trust when you need them. Welcome to the Word on Wealth with Gary Quackenbush. We're here to help you build, protect, and transfer everything you've worked hard for with expert estate planning, trust administration, inheritance, and probate. Call Gary and the team at gqlaw.com. 855-500-TRUST.
You're saving and investing for the future, and that's good. Have you ever stopped to think, where does my money actually go? This is Faith-Based Investing with Anthony Wright.
Most Christians just don't understand that the money they save for retirement usually helps fund the abortion industry and other liberal anti-family causes. But did you know that with just a few minutes of your time, we can screen and clean your investments at no cost to you? It's absolutely complimentary. Just go to the website right now, download a free copy of my book, Faith-Based Investing. It's free as well. You deserve to know the truth as the investor. Then the choice is yours. You can keep doing what you're doing, or you can line up your investments and life savings with your beliefs. We are fiduciary investment advisors. You can feel good about investing with confidence. So learn more now. Go to BibleSafeInvesting.com or call me at 931-RETIRED. Your free book is waiting for you. Go to BibleSafeInvesting.com and be sure that you listen to Faith-Based Investing this weekend right here on Family Call.
Gary, your team at GQ Law are experts at solving IRS and state tax problems. Talk about that.
When people have a tax problem, it tends to really stress them out. And one of the things we've been able to do is figure out how to resolve tax problems. One thing we might be doing is setting up a payment plan or getting a collection delay, maybe getting a determination that the person shouldn't have to pay the taxes at all. We do offers and compromise. We do audit reconsiderations. And one of the things that's a really powerful tool that some people don't recognize is sometimes bankruptcy can be used to actually eliminate taxes when there's certain conditions of the code that are met. So we can do all kinds of things after we analyze your situation. We can figure out what's available, discuss your options, and figure out which ones to implement, what it's going to cost, how long it's going to take. And we can get people out from under all kinds of tax problems so they can sleep again. That's our goal.
Request your free initial consultation. GQLaw.com, 855-500-TRUST. GQLaw.com. Your Christmas table isn't complete without
And about this broadcast outreach, the word on wealth with Gary Quackenbush of GQ Law. Call or click to request your free initial consultation or to talk with a member of the team. Call Gary at 855-500-TRUST. GQLaw.com.
You're live.
Hey, welcome to the Word on Wealth, my friends. This is Gary Quackenbush and Anthony Wright. Anthony is here on the show to answer questions, and he's brave enough to let me ask him questions, which I've interviewed lots of financial advisors, and most of them will want everything in advance. It's funny. So I'm not really setting you up, Anthony, but I do have a question for you.
Yeah, I started to say, man, you're setting me up.
Yeah, setting you up like so, but because it's one of those things. I mean, we're on every week, and it's kind of like, okay, we can talk about these things. Anthony has his own show on KPRZ and KCBQ. He's also got his own on XM Radio, so he's good at this stuff. I just happen to be a tax attorney, estate planning attorney, so I kind of have really specific questions. But this is going to be a question that'll have to do with the inherited IRA distributions under the Secure Act, and then timing of money draws. Okay, so here's the scenario. This is a little bit different. So this client, and this was a particular client, they're asking me specifically kind of some thoughts and ideas. I said, I don't have a lot of ideas. Listen on the show on Thursday. We'll give you some ideas just to kind of chew on, so that he can, because he's like going, oh, who do I use for my financial advice? I said, well, I think you should use Anthony. If you talk to other people, that's fine, but I think you need to get different ideas. So this is not going to be specific to where you say, okay, this is exactly what I do, and I'll send it to you certified. But the thing that happens is like there's $1.5 million in, and it's now inherited IRA. It's in his name, and just got that the beginning of this year. Okay, so $1.5 million in inherited IRA, and then he's got small business income that runs about $200,000 a year. Some of that is wages, and some of that is shareholder distribution. So we have a little bit of a mix of it's a sub S. And then the third thing is that they've got about $1.5 million of non-qualified, which is, money to do whatever you want with, right? So it's a lot of money, and it's good. And it's like, with people with that much money, it's almost like, well, why should I even worry? I can survive on $3 million. And then some of our listeners will look at it and go, wow, that's a lot of money. It is.
Right.
But
Yeah.
you still have a stewardship, right?
Right.
And the concern, so I'm asking, what are your big concerns? It was like, well, I want to be able to leave money for my kids. I said, well, you don't want to ruin them. And he says, well, no, but if my kid wants to live anywhere near me, then I'm probably going to have to be equity sharing or doing something to help him with home. So I'm going, okay, this guy has some plans. But my big question is with the Secure Act, with the Secure Act, where it says that when you inherit money, that's qualified funds. So now it's an inherited IRA, and you've got 10 years to pull it out. And there's been so much like change with the IRS's opinion on what that rule means. And I'm not I'm just kind of not completely sure where that rule is now. Like, is it 1/10 every year? Is it whatever we want? Just pull it all out by the end of the 10th year? Do we have some pretend RMD? Do you know where we are with the latest? And I know it's really kind of fuzzy.
It is very fuzzy. And I actually was hoping you could clear it up for me too, because it's very fuzzy. My understanding is the current administration is comfortable waiting the 10 years as long as you take it out within the 10 years. But then I have talked to other people that claim that no, you have to take a 10th every single year. So it is an extremely fuzzy place to be in the law. And I honestly was hoping you would shine a little bit of light on that myself, because, you know, I'm an investment guy and I work on the investment side. And I wondered about that because, you know, a 72T don't a 72T give you 10 years? Yeah. So, you know, it's possible you could do a 72T and just take it all out in, you know, over that 10-year period of time. But I've had people tell me, just like they have you, that the current administration is fine. Leave it in there as long as you take it all out by the end of the year, you know, 10th year. So it is an extremely fuzzy area. And I don't quite honestly, Gary, know what the real where the real meat lies in that law, honestly.
And it's good to have this conversation. This is kind of, and I know this is one of those where I wish it were more precise. But I think as far as fitting this into our conversation of, you know, money and taking care of things, when the rule originally came out, it said there is no required minimum distribution, which that was referring back to the old RMD where, you know, if I'm 60 years or whatever, 65 years old, I have to take out 1/20, you know, 1/21, you know, for over, you know, the rest of my life and stuff like that. And those charts went away. So our interpretation in the finance market, you know, the tax market was, oh, okay, well, there is no RMD. There's no requirement that you take out any money. It just has to be out by the end of the 10th year. Well, that was fine for the first couple of years. And then the IRS started auditing people and going, wait a minute, you've got $1.5 million in an inherited IRA. You didn't take out 1/10 in those last 2 years.
Exactly.
So then people were really mad about it. And people got big, huge penalties and huge, big tax bills. And so they went and, you know, through the courts and tried to figure out what the heck's going on. And then the IRS said, okay, well, no, it's not 1/10 every year, but we want you to take something every year. I mean, we really want to get some money out of those retirement accounts so that we can tax something, you know. So like kind of the compromise in the legislation was that, okay, we're going to do, and some big financial companies they vary in their opinions, which drives me crazy. I mean, I'm thinking right now of two different huge, huge companies, retail companies that disagree. And so the one thought is you have to take this thing out, they call an as if. So you have to pretend as if it were the old rule, and you have to take out at least the RMD that you would have had to have taken out under the old rule. So like if I'm 65, then my RMD would be like 1/20th of the balance. And I would calculate. So I would have to take out that much the first year and that much the second year. And then by the 10th year, I had to pull it all out for sure. Then I literally, and this made me like, I got a headache immediately. I asked another guy, I said, okay, what's, well, actually two more. So the latest I got was, oh, well, they changed that. And the IRS says it has to be 1/10 for each year. Well, that was the very first time I heard that rule. Okay. I'd never heard that. I'll tell you, if you want to be like really conservative, absolutely. If you take out 1/10 per year, you're good, because that's the most you would ever have to take out. Right. But then the question
that is true.
Is it 1/10 of the balance, or is it 1/10 of the original principal? And you can leave the growth in there. See, they're not discussing that. So another investment house I had, that actually, this was Neuberger Berman. I'll put them on the line. My question for Newberger Berman for
That's
my client
big.
was, yeah, they're huge. It's like, is there an RMD? Got it in writing? No, none. I went, oh gosh.
Whoa.
Oh, I know.
Whoa.
So I am all over. So when I'm thinking of this and I'm talking with you, you always have this really good thing, like, okay, you can go really risky, and the potential penalty for being wrong is loss, market loss, and all that stuff, or you can be super conservative, and then the potential for market loss is zero, or minimal, and the potential for growth is minimal. And I think we're having that problem with this rule under the Secure Act. It's like ultra conservative would be you take out 1/10 every year. Okay. Less conservative would be you have to take out at least the kind of as if RMD and then have it all out by the end of the 10th year. So tying it into that scenario that I have, kind of pinned you with is like, here's a guy that's 63 years old and he's still making $200,000 a year, but he'll only make that for 2 more years, basically, to make it easy. So he doesn't want to take $150,000 out this year and next year and bump his income to $350,000 because he has other investments. So he's going to be getting up into the really high tax brackets. He would rather take out like kind of a pretend RMD, or what they call the as if RMD this year and next year, which is going to be 1/20th or $75,000. And then in year 3, 4, 5, 6, 7, 8, 9, 10, take out a bunch because he won't have his regular income anymore. But the thing, and that's why, and I'm not trying to pin you to this. I just, everybody's kind of, not everybody, there's just different stories on where we go. What the IRS did on the first 2 years, which is 2020 and 21, is they actually forgave all penalties 100%, as long as people, quote, caught up. Crazy. And I saw some of those things that came out, some of the sheets from the IRS, and they were just literally forgiving penalties. They just said, well, if you get caught up, and caught up to what? 1/10? No, the catch up was you have to get caught up on an as if. So you look at $1.5 million account, the as if based on your age would have been the RMD maybe 1/19th or 1/20th, depending on the old chart. And then that was safe. So they're not
crazy stuff. I'm
know.
telling you, IRS gets crazy. They do crazy stuff.
It's too frustrating to me because I don't like the penalties and stuff like that. And I think, for this conversation to not get it to where we're really in the weeds, the thing that we do when Anthony and I work as a team is Anthony is a fiduciary financial advisor. He'll tell you with your stocks, bonds, mutual funds, your beans, your everything as far as getting in investments. And I'm showing you that Anthony, we team up on things. If there's issues with the inherited IRAs, with the Secure Act, then we got to talk to the client. We got to get in there. And that's the whole thing. You don't really want to get tangled up in an investment house where everything is online and you really don't have an advisor. I just think that's a bad idea. I think you need to get somebody like Anthony, who is like flesh and bones. He and his team are awesome. They will run through these scenarios and they run through this risk analysis. And I think part of this risk analysis we're dealing with now is this crazy Secure Act, unfortunately. But
Agreed.
So
and I think my understanding that other people are telling me, Gary, the clients that are coming in that are telling me they're calling
1 minute
the IRS, they're telling me that the IRS has been telling them that as long as they take it out by the end of the 10th year, that they don't have to take a 10th. But I like your approach of take a 10th per year just to be sure. But it's such a gray area. It's hard to know and determine what's the real true meaning of the law.
So I think all of it, because right now that's literally where we are. There's all these little test cases out there. And I think it's a matter of get your financial advisor like Anthony and you figure that out. Look at where it all times out. And with your timing, should we go really risky and take none out? Should we take out 1/10 or should we take out something in between? And those are things to talk about besides trying to figure out where you're going to make money. You've been on the air today with Anthony Wright and Gary Quackenbush. Anthony, I really appreciate you taking your Thursdays and talking to us. I just want everybody to give you a call at 931-RETIRED. I give out your number probably 4 or 5 times a week. And I appreciate you taking the time to be with us, my friend.
Hey, I appreciate you having me on. Thanks a bunch, Gary.
You're
Look
welcome.
forward to seeing you, pal.
All right. Take care, man.
All right, man. See ya.
All right. We'll be back here on the Word on Wealth.
You've got questions. We've got answers. This is the Word on Wealth with Gary Quackenbush of GQ Law. Gary's here.
Taste of the week or anything? Or good?
$500.
You're live.
Welcome to the Word on Wealth, friends. This is Gary Quackenbush. We just had a really good conversation with Anthony Wright. He is, he's a good guy. You can see by my conversation with him. It's hard. I wasn't trying to put him on the spot. That's it. Kind of, we really both ran into a question that we're having trouble with because I've been talking to a lot of different people, different financial advisors and tax professionals about the rules surrounding the Secure Act. It's just something you can't mess with. If you have retirement accounts, especially if you have inherited retirement accounts, and if you inherited them since the Secure Act came into play, that would be during 20 and 21, then you're affected by that law, and there's nothing you can do to get around it. It's the act that the federal government came up with where they defined inherited IRAs as completely different. Now, they've been treated differently since like 1994 when there's a big ruling, I believe is the Jockaway case. So there's big ruling that was saying, oh yeah, inherited IRAs are not IRAs. It changed how they were protected in bankruptcies, in creditor attachments, and any type of financial stuff. And as a result, it started to alter and say, well, inherited IRAs are not IRAs. They're inherited IRAs. They're treated differently. So then when the Secure Act came out, the whole inherited IRA thing changed. Okay, you may be thinking, well, I don't have an inherited IRA. My dad had a TIAA because he was an educator. So he has a TIAA. And so it's not an inherited IRA. Well, when you inherited that money is now treated as an inherited IRA. Okay. An inherited individual retirement arrangement. So inherited IRA. If your parent had a 401k because they work for a big company like HP or Microsoft or something, and now most companies now have a 401k, and you inherit, $300,000 or $400,000 out of a 401k. It is not an inherited 401k. It is an inherited IRA. And as a result, it falls under the Secure Act and those rules. If your parent had an IRA and they pass away, that is now an inherited IRA. That's the most clear. But everything you inherit from that was retirement money, which is qualified money, we call it qualified funds because under the Internal Revenue Code, it is qualified to be tax deferred. It gets put into the account before it is taxed. So it doesn't show up on your tax return as taxable. It doesn't show up on your pay stub as taxable because it goes in pre-tax. It grows pre-tax. When you take it out, it gets taxed. Okay. Now, if it was an IRA and it were your own, you could just, if you didn't need it, you wouldn't take it out. You would leave it for your heirs, for your children. When your children get it, now it's an inherited IRA, and the IRS doesn't want to stretch it out and let you, take it out of that account over the next 20 years under the Secure Act. They kind of went in and said, hey, we're securing retirement for all people. And what they really were doing, and this is not to get political, but what I see happen was it wasn't securing retirement for all people. It was getting more money out of these inherited IRAs than the law previously allowed. For example, it was a 60-year-old guy that inherited money, then under the old rule, he would have had to take that money out over the next 20 or 22 years, depending on the mortality tables. Well, under the Secure Act, he has to grab it in 10. And if you put it into a living trust that wasn't an asset protection trust or a retirement protection trust, it would have to be pulled out within 5 years. So the acceleration is just huge. So now we have this Secure Act, and we know that if you inherit an IRA, that money has to be drawn out of the inherited IRA account. It has to be drawn out within 10 years of the date of death. Okay. So the year they die, you go to the end of that year, you count 10 more. That has to be out by the end of that 10th year. If it is not, there are enormous penalties, huge penalties, like 50% of what you failed to take out in time, plus the regular tax. So it's huge. As a result, we're having the struggle right now in the financial markets and trying to figure out what the IRS wants. We know what the law says, but we're getting interpretations differently. There are some companies that will say you have to take it out 1/10 every year, so that by the end of the 10th year, you take out the last 1/10 and you're done. There are other companies that are saying, no, you don't have to do that. You only have to take out as if it were your own IRA and you had a required minimum distribution. So you look on the old charts. So those are the two things that are a little bit conflicting. I mean, to be safe, you take out 1/10, and then, that's the most strict that the IRS can interpret that rule is that it's 1/10 of the retirement account. And there's been some cancellation of penalties for the last couple of years. So there's just a lot going on with that. So I suggest that with you get a good financial advisor, a good tax advisor. With me, I would go with Anthony, 931 retired. Talk to him about your financial situation with your retirement accounts. And he's got all this down, and we can advise you, what's risky and what's not, and how to take care of business. So that's what I do. And that's what I would suggest you do. All right, switching topics. I want to answer some questions about power of attorneys. The power of attorney document it's a piece of paper where if you give someone your power of attorney, you give them power to make decisions for you. So all power of attorneys do that. It's the person giving the power and the person receiving the power. The recipient of the power is now called the attorney in fact. All right. So for health reasons, the document that my office prepares is called a healthcare power of attorney, because it assigns or designates someone to be your power of attorney, which means they can act in your behalf. That power of attorney has the ability to make decisions for you, medical decisions, to treat or not treat, to and the ability to instruct the doctors life support, no life support, burial or cremation, and make all the decisions. Okay, so the main purpose of the document is to assign someone the task of making those medical decisions for you when you cannot. The second purpose of the document, we call it a physician's directive or your living will. Well, the living will means you're making these decisions now for if you are still alive or during that process of dying that you want some decisions made. So it's going to be the instructions to your healthcare power of attorney that says, my preference, if, and the circumstances are very similar in most power of attorneys, but it's like personally me, my preference is I do not want to be on life support. Okay. And the conditions in the power of attorney that I have says, I don't want to be on life support if the following conditions are met. So there's like this checklist where you go through and say, 1, if I am in an irreversible coma. Okay, irreversible coma is a medical term. Irreversible coma is a different medical term, right? So is it an irreversible coma? The way that works is my power of attorney would go to the doctor and say, is Gary in an irreversible coma? And then the doctor and their committee decide, and they say, yeah, we believe to a medical certainty that this coma is irreversible. Okay, under that condition, I want life support removed. Okay, number 2, if I am terminally ill, or if I am in a persistent vegetative state. Now, vegetative is a condition of the mind where you have no brain function. Okay, is it persistent? Meaning, is there any way that's going to change? And the doctors would have to determine. They'd say, well, to a medical certainty, we've determined that it is a persistent vegetative state. It's not changing. We don't expect it to change. There's no medical reason why it would. Okay, life support removed. And the third one is if I am terminally ill, which means I'm going to die from the illness I have, period. And it's going to be within a short period of time or not. But if I am terminally ill and the application of life support serves only to delay the moment of my death. So what I want so I'm giving more latitude to my power of attorney that says, if I'm dying from, if what I have is going to kill me and take my life, then if the machine just drags it out, then I want to consider, is keeping the machines on, is that going to make it worse or not? And if it's going to make it worse, I don't want life support. It also has language, typically the one I use, like, I want pain medication. I don't want to be, in agonizing pain as I, go out of this world. So, do the pain medication, stuff like that. So that's part of the power of attorney. Then it will have, do I want to be buried or cremated? Do I prefer to donate my organs?
Not a minute.
Am I authorizing an autopsy? Those are the different things in the power of attorney. That has to be updated since 2015 because the Obamacare laws changed all the disclosures that have to be included in it. So that's something to look at. If your estate plan and your power of attorney is all like older than 2015, that's 7 or 8 years ago, guys. It's time to update it, get it up to the latest laws, maybe do a new healthcare power of attorney, healthcare directive. Look at your will and trust, make sure it's what you want, make sure the guardians are proper and the successor trustees are still willing to serve, and the distributions are what you want. Those are things that can be amended. We can do an amendment. We can change certain things. You can change the whole entire trust and start over. All that is possible. We do that on a daily basis, and we love doing that for our clients. If you want help with that, 855-500-TRUST, 855-500-TRUST. You can call, get an appointment with me, free initial consultation. We'll go over it, review your trust, and see if that's where you want it to be. All right. The next thing we want to talk about is there's some problems. I'm going to call it the problem with being myopic. Okay, with estate planning is being myopic, single vision. And that's what I'm going to talk about coming up next here on The Word on Wealth.
You don't need to know everything. You just need to know where to find answers you can trust when you need them. Welcome to The Word on Wealth with Gary Quackenbush. We're here to help you build, protect, and transfer everything you've worked hard for with expert estate planning, trust administration, inheritance, and probate. Call Gary and the team at gqlaw.com. 855-500-TRUST.
Gary, listeners are asking about trust disputes and whether or not they'll actually get the inheritance they're expecting.
I think that's a scary thing for most people because they feel like, if I ask my successor trustee, hey, where's my inheritance? You kind of feel like, oh my gosh, I'm being like rude or whatever, inconsiderate. But I'm telling you, if time goes on, if it's been like 60 days, 90 days, 120 days, that's too long to have heard nothing. You're supposed to hear fairly soon, like within a couple of months after someone's passed, you should be hearing from that successor trustee. And if you're not, I think there's an issue we need to address. So it's not like we're going to go screaming in there and filing lawsuits. We kind of use gentle nudges like, hey, do you know what you're doing? Successor trustee, we kind of want to help you do your job, and we help beneficiaries kind of get things straightened out.
Call or click to request your free initial consultation. GQLaw.com, 855-500-TRUST, GQLaw.com.
About this broadcast outreach, the word on wealth with Gary Quackenbush of GQ Law. Call or click to request your free initial consultation or to talk with a member of the team. Call Gary at 855-500-TRUST, GQLaw.com.
You're live.
Hello, friends. Welcome to the Word on Wealth. This is attorney Gary Quackenbush talking about being myopic. The problem with estate planning when you're myopic, well, what does that mean? It's like, doesn't that mean you have one eyeball? I think so. No, that'd be cycloptic. Myopic, single visioned, narrow visioned. Story in Mission Trails. It's a really neat rock climbing area in San Diego, Southern California here. And it's actually got some world-class rock climbing. And there's one climb. When you're rock climbing, they have they name the routes. Okay, this one is called Monkey Dance. It's rated at 10.2. That's on a scale. It's called the YDC, the Yosemite Decimal System. Anyway, there's this whole system of how hard climbs are. And there's one that's kind of a moderately hard climb called Monkey Dance. Well, I climb it. It's rock climbing, and I'm lead climbing, so it makes it more fun and more exciting and more adrenaline rushy. And I climb it, and my son's belaying me. He's the one that's protecting me, right? If I fall, then I fall back down past my last point of protection, and he catches me with the rope, and I pick myself back up and finish the climb. So in this particular climb, I had my son Tyler, and I was done. I belayed back down, and then he went on belay. So we switched places. I'm now his belayer. He is now on belay. He's the climber. And he gets up the first part. You have to really grab this ledge, and you put your heel up, kind of up by your face, out to the side, and you kind of roll up. You try to get your hips up, and, you push with your hands, called a mantle, and you get to where you stand up on this little ledge. Okay. So from the ledge, you can now stand up, and you can clip into your next piece of protection, which is basically up above your head. So now you're safe. If you fell from right there, you wouldn't go very far. So I'm trying to tell Tyler, look, the way you do this is you reach your right hand, as far as you can up and to the right, and you put your hand in this little book shape we call the dihedral, and then you wrap your other arm around the other side, and you bear hug this thing. And the bear hug gives you enough, grip to the wall where you can put your feet up in the dihedral and one on this other little crack. And I would do that, and I would step up. I'd get up another foot. I would move my bear hug up a little bit, and I would move my feet a couple of times, and then I would be able to clip into my next area, my next protection. Well, Tyler was trying to do that, and I'm saying, Tyler, you got to reach further. Dad, I can't. My arms aren't as long as yours. I said, what you can, you just have to get yourself up a little bit higher. So I'm going through this whole process because, well, I climbed the rock exactly the right way because that's how I got up that rock. And I was trying to get him up the rock my way. And I figured that's got to be the right way. Not that I'm always like, oh, my way is the right way, but it was a kind of a hard climb. Well, he ended up just saying, oh, forget this. And he does what we call climb angry, where he gets mad and just says, I'm just going to do it my way. So he ends up putting both hands in the dihedral, and then he gets his toe up there. So both sides of his shoe, one is on each side of this little book. It's like having a book halfway open, 90-degree angle. And that was enough to get his toe locked in. And then he reaches up and finds another ledge with his left hand, pulls himself up with his left hand and his foot in the dihedral, clips up the next, and then finishes the climb really fast. And he belays back down. And he says, that's the way I do it. Well, I thought, that's fantastic. That's wonderful. I just didn't see it. All I could see was the way I did it. And I didn't realize there was another way. And so then when we go back, sure enough, it's that way. It's the way I did. There's a couple other ways, but I was being really myopic. So the way that relates to estate planning is I am troubled at times when we're dealing with a situation where somebody was myopic. So I'm going to talk about cases where the people have passed away, and now we're dealing with their estate plan, this myopic estate plan, as we're going to call it loosely, that caused problems that made it so that the survivors, the people here on this planet who were trying to get the money transferred to them and to the other beneficiaries, they had to spend a lot of money on attorney's fees. One, for example, was a woman that did not want, this is a long time ago, a woman that did not want to do a trust because it was too expensive and she did not like lawyers. So her nephew went and downloaded or bought a package on a disc, a CD. This is back when we had CDs, and put all the basically put it all on his computer and typed in all the information, put in where the aunt wanted the money to go, and made sure, are you sure you want to give it to me? Yeah, I want to give it to you. So all this went on. And as he went through the document, there were certain things that he noticed that he didn't like. Like, why is there a signature like in 4 different places in this document? What he didn't recognize is the document. There were 4 different documents. And that's why it was just all in one big long one, but they still were 4 completely separate documents. It was a will and a trust and a power of attorney, and a personal property transfer. So there's 4 documents, if I can remember that clearly. And he thought, well, that was dumb to have that many signatures. Just take out the signature, put them in one big long document so that it read, here's the trust, here's the transfer documents, here's the will, here's all this. And then it gets signed and notarized and witnessed all in one page, rather than doing it properly, which would be witnessing the will, notarizing the trust, notarizing the power of attorney, and putting together the proper deed. So he basically messed up all the legal procedures. He did it for his aunt. He made it so the property all came to him. Well, what do you think happened? The aunt dies, and he now tries to put the house in his name because the aunt said he could have all of her property. So he tries to put the house in his name, and that it was messed up enough where the title company said, no, this is not a proper document. We can't use this trust to transfer the house. Something's messed up. So we had to, it was time to go to probate court. Well, in probate court, everybody, all the heirs got notified. The aunt had the aunt had a brother and a sister, and but no children. So you have the brother and the sister, and then the nephew is getting the money. And the brother and sister ended up coming into probate court and saying, actually, no, that's not what was supposed to happen. And they filed a lawsuit. It was determined that the trust was improper. It wasn't clear that that was her intention because the documents were so messed up. It wasn't witnessed properly. It was notarized, but the language was unclear as you read through the trust. It wasn't really clear what was supposed to be happening. And kind of the kind of nail that kind of sealed the deal in the wrong way was that the guy that actually put together the documents was the one getting all the money. So what ended up happening is the brother and sister came in and said, no, she died without children. It comes to us, which is true. If there was no will and no trust, they would have gotten all the money. So they came in and basically said, throw out this piece of garbage. It's not done right. It's not witnessed properly. There's nothing saying that, our sister was competent, and we think she was compelled fraudulently. She was forced, cajoled, talked into, convinced, or whatever, to create this trust document that was actually drawn up, drafted, pieced together by the person getting all the money. So it was a compelling thing, unfortunately, because the court looked at it and basically was saying, well, that's one side of the thing. The nephew wanted all the money and he drafted the trust, absolutely sure that that's what his aunt wanted. And then the brother and sister came in and said, no, you did that. You probably coerced her. Maybe you got her drunk. Maybe, you were there, forcing her to sign it under the threat of leaving her and not taking care of her anymore. But it just caused a lot of problems. And that was the myopic thing. For me, I will just do the trust for my aunt because she doesn't want to do her own. We're going to save money. We're going to save, and it's going to be easy. I can do this. Well, he saved money. No, he didn't. It was about a $60,000 problem that was caused, and he didn't get the entire estate. He only got a piece of it, not a very big piece of it, because the way it looked like it was crafted in a way that was, done undue influence, we would call it. Okay. Then the other one, this is another myopic thing, a little different than estate planning. But this is a scenario, it's different, where what happened is this friend had done some research and probably looked it up on Google and on YouTube and whatever, and said, hey, it's a good idea to be a corporation. So so he talked to his friend and said, hey, you should be a corporation. I read all about it and I can do it for you because I looked up the forms. Okay. In fact, I can do it for you because I can actually download the forms. I can do a kit, whatever. And the friend was like, I don't know. If you think you can do it for me, then that's fine. Well, the guy that's now putting it all together, drafting the forms, is not family. It's not a spouse, not a child, not the parent. So he's creating legal documents that have legal effect on this guy's business. That is actually the illegal practice of law. So he is playing lawyer. Maybe he gets it right, maybe he doesn't, but either way, it's not legal. He can't be somebody else's lawyer because it's not family, it's a friend. Okay, and that may seem weird, but we're trying to protect people from, fake lawyers. So what ended up happening is the business, stuff happened and the business got sued. And the first thing was, give me your books and records. Well, they weren't all done quite properly, and they ended up defeating the corporation. They just blew through the corporate veil because the friend that put it together didn't do all the right steps to set it up properly. He got he got the articles of incorporation, which easy pleasy, anybody can do that, but didn't finish all the paperwork because he thought, oh, that's dumb. It's one owner corporation. Why should I do minutes? Well, because it's legally required. So what he did was, not only did he create the documents, acting as an attorney, which he shouldn't do, he also didn't even do it right. So that's even a bigger problem. So is his friend like him anymore? That was a huge, big mess, big lawsuit and all that stuff. So it's kind of like, I'll just fill these forms out. It's just filling out the forms. That's myopic. It's way more than filling out forms. To create a trust, to create a will, to create a corporation, that's all legal stuff. I'm happy to help you with that. Let's do it right. Let's get it right the first time. 855-500-TRUST, 855-500-TRUST. We'll see you tomorrow on Feel Good Friday here on the Word on Wealth. Bye, everybody. Have a good day.
Man, that was close.
Tell a friend about the Word on Wealth, featured since 1995 with financial solutions attorney Gary.
Good.
I've even learned to give you a couple